Um, I'll begin with an overview of the partner visa options for Australia. There are three main options if you're an Australian citizen or Australian permanent resident for sponsoring your partner to Australia. These are also applicable for eligible New Zealand citizens, with the 26th of February 2001 being a key date there. Other New Zealand citizens need to sponsor family members through the 461 visa, which I believe we had a recent webinar on previously. So for Australian citizens and permanent residents, there are three options. The first is the onshore partner visa. This is applied for when your partner is within Australia and generally when they're holding a valid visa in Australia is the most common time you would apply. The 820 is usually granted if it's a short-term relationship of under 3 years when you apply for the visa. The 801 can be granted on the first instance as a double grant with the 820 if your relationship is assessed as long-term. More commonly though, the 801 is applied for with a further submission provided 2 years after the date the 820 was originally applied for. The offshore partner visa, it's in the name, it's applied for when your partner is overseas. It generally suits best to couples living together overseas, as you do need to show a full partner relationship for the offshore partner visa. So it makes sense, for example, if you're an expatriate Australian worker based in an overseas country with a partner from that country or a different country, and you're living together full time outside Australia. That's when the offshore partner visa would make sense as an option. The third visa type and the 309 is somewhat equivalent to the 820. It's the temporary visa and the 100 is the permanent visa. Again, the 100 is only granted on the first instance if it's a long-term relationship. If not, you will need to do a further submission for the 100 2 years after you apply for the 309. The final option is the prospective marriage visa. This is usually well suited to couples where one is living in a country outside Australia and the sponsor's living within Australia. The evidentiary threshold for the prospective marriage visa is slightly lower, as what you're showing is an intention to enter into a married relationship rather than an already existing fully fledged de facto or married relationship. A common circumstance where this will occur is if you've met your partner briefly or on a couple of trips overseas, your partner's living in that country and hasn't been able to get a visa to Australia. In that case, where it's a long distance relationship, the prospective marriage visa is generally the most suitable partner visa there. Okay. Yeah, getting to the next slide. This largely covers what we have just discussed. Some of the key benefits of the 820 and 801 compared to the other options are that your partner can access Medicare while the application is processing, which is something people are generally interested in when moving to Australia, being our public health system. Another key feature of the 820 and 801 that provides benefits compared to the other partner visa applications that can be lodged is the full-time work rights within Australia available. So knowing the salary differences between Australia and other countries, it does usually make sense to do an 820 where it is possible to do an 820 801 application, because even the travel prices to Australia or the cost of the visitor visa, they're well and truly offset by the differences in income and healthcare cover in that processing period of a year or so. Children can be included in all of the applications. There are some additional fees if you have secondary applicants, but yes, children can be included, whether they're from your relationship or dependent children. Yeah. When granted the 820 and 309, you can think of it as somewhat provisional PR if it's only an 820 or 309 granted on the basis that the relationship keeps going. And then in 2 years, that's when you can apply for the permanent partner visa. The 309 is a little different in that you need to marry following the visa grant. That's not the case for the 309 or 820. So for the 300, your partner would need to enter Australia after the visa is granted, quite naturally. You'd then need to marry in Australia following the visa grant. And then after you marry, the 309 is a temporary visa. So you would then need to apply for the 820 and 801 and go through the 820, 801 process following the 300. Does anyone have any questions at this stage? Okay, in that case, we'll continue on as to some common issues that we have seen occur when people apply for partner visas and may come to us after having self-lodged an application or done it with someone who didn't necessarily take the care they should have as a trusted advisor for the application. The first major issue that we see far too commonly is inconsistent evidence or insufficient evidence. Inconsistent evidence is probably the worst, as it can undermine the credibility of you and your partner in your application. A common example is generally both partners will provide relationship statements with the application. The visa applicant, so the partner applying for the visa, will be submitting an application. The sponsor will also be submitting an application. If the dates don't match up, in those applications or the supporting documents, then the assessing case officer from the Department of Home Affairs will naturally be highly skeptical of the relationship, and understandably so. Further, if there are contradictions in event timelines, what happened, how you met, etc., those can cause significant issues for an application. So it is important that they're managed correctly. Insufficient evidence is also something that can lead to refusal. Insufficient evidence largely occurs when either it's an offshore application from a country where documentation is not as much of a priority as Australia, and it's largely a cash-based society. So you won't have the natural document build up that you would if you were in a relationship in Australia. For example, instead of having documented shared finances, you may just be paying cash for things and passing cash between each other as how you manage the relationship. So it is important to engage professionals there if there's potentially going to be a barrier to actually documenting your relationship, so that we can help you do it in a way that's satisfactory for the department. The third way insufficient evidence comes up is often an asset. A partner's potentially trying to protect assets, usually the Australian sponsor, and they're trying to take a minimal approach to the partner visa application. There it can be tricky because yes, asset protection should be a priority, and we understand it being a priority. It does just need to be managed carefully so that we're still showing a full partner relationship, either as married partners or de facto partners, alongside that asset protection element. Going to the next common issue we see, a lot of people, somewhat common sense, believe marriage helps for a future partner visa application and will marry before seeking professional advice. I'd strongly advise against marrying before seeking professional advice on your relationship and the pathways for your relationship. The reason being, marriage takes away eligibility for the prospective marriage visa application, because you can't apply for a prospective marriage visa to marry in Australia if you're already married. It would then mean you need to go through 820 or 309. If you can't get a visitor visa for the 820 or a visa to Australia to then apply for the 820 from, the 309 application can be challenging if you're wanting to live in Australia and your partner's living in a different country during processing, because the household element of the relationship you just aren't sharing a household in the same way that couples who are living together are, which is why the 300 is generally the best option for long distance relationships, and marrying too early can make the 309 challenging and delay processing. So it is important to seek professional advice before marrying, and not just assuming marrying straight away would be a good thing for a visa application to Australia. Um, a next issue that we've seen come up recently is applicants self-lodging and thinking a bridging visa is a substantive visa. A bridging visa, for those who aren't aware, is a visa that bridges when you apply for a new visa within Australia. For example, you may be holding a student visa and you apply for your graduate visa. Following your student visa expiry until the graduate visa is decided, you would likely be on a bridging visa if you lodge that application within Australia. However, for the partner visa, it is critical to note that a bridging visa is not a substantive visa. It's only to bridge between applications. You can still apply for a partner visa from a bridging visa, which is why some people will make this mistake. However, it attracts what's called Schedule 3 criteria, and you need to show compelling and compassionate reasons for the visa to be granted rather than just a normal partner relationship. And it does make it significantly harder as an application if you apply from a bridging visa. The next one is underestimating processing times, especially when self-lodging. A lot of self-lodged applications, just being objective from what we see, have insufficient evidence, and the standard processing times are up to 2 years for the 309 and 820. This is again why we recommend the 820 is so you can live in Australia with your partner during the processing times. Whereas again, this goes back to marrying too early. If you marry too early and you end up having to do a 309, it can be that up to 2 years in processing because you have relatively weak household evidence for a 309 in a long distance relationship. So you just need to be aware of it at the time you're applying for transparency. Again, as we mentioned earlier, the bridging visa for the 820, when you apply, it comes with work rights and Medicare access. So doing that 820 application, especially if the partner applying for the visa is from a relatively lower income country than Australia, the work rights and Medicare access can be of significant benefit, even during that bridging visa period, which we just mentioned could be up to 2 years. For example, 2 years working full time in Australia, even if it's on a relatively low wage of, let's say, 50,000 around minimum wage in Australia, that's still significantly higher than even a high wage in many other countries where the average wage is more in that 5 to 10,000 AUD range. And over a 2 year period, that can be almost an $100,000 difference for the same work in the same occupation, whether you're in Australia on a bridging visa or overseas waiting while the application pens. We'll get briefly into what constitutes a relationship that can apply for a partner visa. Again, does anyone have any questions before we get into the next phase of the webinar? Okay, we'll continue on then. So there are two types of relationships with which you can apply for the partner visas, excluding the prospective marriage visa. The prospective marriage visa has a lower threshold than both of these because you're only showing the intention to enter into a relationship. So a spousal relationship, you must be married and the marriage must be recognised under Australian law. The most common marriages that wouldn't be recognised would be a purely customary marriage with no legal recognition in that country. Most marriages that are valid overseas are recognised in Australia via family law, and the Migration Act refers to family law for what they consider to be a marriage. De facto relationships, this can be, again, same as marriage. It can be a same-sex or opposite sex or a straight couple. The key difference is you're not married. If it's a de facto relationship, the good way to think of a de facto relationship is you are de facto married in terms of how you live together. So you're living together, you're sharing finances, you're not just dating or a boyfriend-girlfriend relationship. You are a full de facto relationship, sharing many of the traits of a married relationship. There are 4 key elements. These are assessed by the department whether the relationship is spousal or de facto in nature. So again, going back to marriage, a marriage certificate alone isn't enough for Australian partner visa applications. You do still need to show 4 aspects of a relationship for it to be considered a spousal relationship rather than just a paper marriage. The first element is financial aspects. So this is showing that you share your finances as a couple. So either as a married couple or as if you were a married couple. So sharing your financial obligations within the household and your expenses. The next is the household. Going back to what I mentioned earlier, this is where long distance relationships generally can run into an issue. The household element, it looks into how you share daily life together. So basic things such as who does the cooking, who does the dishes, who does the bins, who takes care of the lawns. It's basic stuff if you're living together, which is why it's very important to make sure you apply for the right visa in the first place. Because if it's long distance, you can run into trouble with this element of the relationship. And yeah, it is just looking at domestic life together. Next is social aspects. So you do need to show that your relationship is recognized by family and friends. You can't be keeping the relationship a secret from your family. If your family and friends are aware of your relationship, there's generally not too many issues with this element. An important thing to note is you will need to get reference letters if you apply. There are specific requirements surrounding those, and there's a form that is to be completed for them called a Form 888. With those social aspects, it's showing that your relationship is recognized by friends and family. Again, the main thing is it's usually evidenced through invitations to family events, photos with family and friends where you're clearly representing as a couple, and reference letters. Going to the nature of commitment, this largely relates to future plans together, the development of your relationship. So would a case officer from the Department of Home Affairs look at your relationship and see the development of it having made sense? So how did you meet? Was there a phase of dating? When did you progress to either being de facto or married? How did that occur? What are your future plans together? Is there that ongoing commitment to a shared life together? This is where a marriage certificate does come in, as it's a pretty significant commitment. In most states and territories, there are also civil partnership certificates available if you register your relationship in that state or territory. Again, those are quite strong commitment evidence. They're just not available in WA or the NT. Another thing at this stage is statutory declarations really help. Making that declaration as to your future plans together as a legal declaration rather than just a letter saying your plans together. And finally, if you are in a long distance relationship, you will need to show communication history from throughout that long distance relationship and that you have maintained that commitment despite the physical distance in a long distance relationship. Okay. Yeah, some regular issues that we see on each element. On the financial element, a lot of people think joint accounts alone are sufficient. For example, they might open up a joint account with a bank. That can be good evidence, but if it's just a shell account or a skeleton account and not actually used, the Department of Home Affairs aren't going to give weight to it as evidence. No ongoing legal commitments. You don't have to have ongoing legal commitments. It just helps. For example, if you have a car loan as a shared car loan, or even something as small as a phone bill or a Spotify subscription, that you are sharing as partners. Doesn't have to be a big commitment, but they're just small things you can do to help out the application, like a subscription to Spotify or Netflix as a family. Last is undocumented money transfers as a common issue we see, where people will be transferring money but not be able to document, or they'll be sending cash overseas, or they'll be living together overseas in a cash-based society, having their own individual bank accounts and just managing finances on a cash basis. That can be hard to document and evidence to the government in Australia. Going to household, the main one is applying for the wrong type of visa in the first instance. That's usually where people run into an issue with this element. No clear household responsibilities. It's usually not sufficient to just give a vague statement like we share household responsibilities. The department does like seeing specifics. And finally, one partner doing all the chores, both inside and outside the house in a statement of household responsibilities. It could raise some red flags with the department if there's no sharing whatsoever as to household responsibilities. So it is, yeah, you just need to make sure to cover that. Social aspects, being camera shy is unfortunately one of the things here. I've seen it on Instagram Reels and a little bit lately, where there have been people making reels about the number of photos they take for partner visas to Australia. It is something you do need to do, is taking photos together and with friends at events that you attend. Not taking photos together or being camera shy, the department will have some red flags with that if you have no photos with your partner. Another criteria is you need to show you and your partner have met in person, and the most common way to do so is a photo together at a location, especially if you're applying with one partner in Australia and the other partner overseas, just to evidence an in-person meeting as well. Not updating social media relationship statuses. This is important if you have social media accounts that you don't really use anymore. The government can check these. So, for example, if you have a Facebook account with your name, even if you haven't used Facebook for a couple of years and your Facebook relationship status is single, it could raise some red flags with the department if they search and they find your Facebook account saying that you're single when applying for a partner visa, just due to the inconsistency involved there. So it is important to keep track of your social media accounts and make sure all of them are updated. So if the government were to check your social media, there wouldn't be a major red flag raised where you're socially representing yourself as not in a relationship. The next one is not updating government services. So if you receive a government benefit of any form, it is important to update them that you are in a relationship. It's not something you can have both ways, where for one purpose with the government, you want to be considered as in a relationship for a partner visa, and for another purpose, you're telling the government you're single when it's of benefit to you. So you do need to keep the government updated as to the relationship and make sure to keep records of that and show them that, yes, I have updated all my government services. All of these government services are aware I'm in a relationship. The Department of Home Affairs should be too. And should therefore approve the visa. The last one is poor quality Form 888s, where it's just a general one sentence statement without any actual insight as to how the witness knows you and your partner or reasons why they believe your relationship to be genuine. Finally, going to commitment, not registering a relationship or marrying. It's not 100% critical that you register a relationship if your de facto relationship's over 12 months. However, the department may have questions as to why you haven't registered, and there would be a flag for them to look at and scrutinize the application more carefully. Wanting it both ways is how I've put this one. So again, this is the minimal commitment for asset protection, where people will try and do a bare minimum partner visa application for asset protection purposes. It can raise concerns with the department as to just how committed you are to the relationship. If you're doing all of these asset protection, taking significant asset protection measures, then the department may have doubts as to how committed you are to the relationship if you're protecting every asset you have from the relationship. yeah, it's just the inconsistency there that they would see, and not documenting communication when long distance. For example, you have call records, you lose your phone, and then there's no documentation available. Please do it through platforms or just back up the communication records in case something does happen to both of your devices, so that there can be that documentation if requested. Okay, again, does anyone have any questions at this point? Yeah, so for the long distance relationship, you can do a statement of shared responsibilities. It would focus on the time you've spent together. Um, it's a requirement to apply for the visa that you've met in person. And with that, you would likely have spent a little bit of time together. Again, long distance relationship, we're recommending the prospective marriage visa. So with the prospective marriage visa, it can be how you intend to share responsibilities following your partner's arrival in Australia. If you've already married and you're in a position where you're having to do a 309 application, it would be prudent to potentially visit your partner overseas for a month or so during the processing so that you can live as a household and then provide a strong statement of shared household responsibilities, having lived together for that month period and established a routine on household responsibilities. So there are various ways you can go about it depending on the visa type. The minimum months required to apply for a strong partner visa relationship. Australia has no minimum duration if you're married, unlike some other countries where there may be shows such as 90 Day Fiance. The US is the most common one people are aware of. Australia doesn't have that minimum, but I'd treat 3 months as a general rule. If it's a de facto relationship, there is a minimum period of 12 months, unless you can show a compelling or compassionate reason. The most common compelling and compassionate reason for a de facto relationship of under 12 months is relationship registration. The department treats that the same as marriage for waiving the 12-month requirement. If you're based in the WA or NT, you will need to establish a different compelling or compassionate reason if the relationship's under 12 months. And if you're based in the WA or NT, it is best usually to wait for at least 12 months. Regarding too early relationships as a red flag, there could be questions as to the relationship development if it seems like an unnatural relationship development and it's not clear as to how you progress to the point of being de facto partners or certain elements weren't established in the relationship. That's more the issue with early relationships is you'll have evidence issues. As a general rule, though, I'd say 3 months. That's more borrowing from US law, but from our experience, that's how long it takes to show shared finances, shared household, fully integrate into each other's social lives, etc. Okay, I hope that addresses both of your questions, Emily and ST. Moving forward into some potential red flags or more complicated situations than the standard partner visa applications we've been discussing. Sponsor immigration history. If the sponsor sponsored another partner within the last 5 years or was sponsored themselves within the last 5 years, they will have a sponsorship bar applicable to sponsoring. From our experience, this is very hard to waive. And even in circumstances where there are some compelling and compassionate reasons, the department can still refuse an application and want it to go to the tribunal so they get oral evidence from both sides. And objectively, this is more of a subjective opinion based on our anecdotal experience with partners trying to waive the sponsorship bar. The department somewhat tests the relationship in such circumstances with longer or delayed processing, sending people to the tribunal via an initial refusal that may not fully be logical, etc. So it is good to wait until that sponsorship bar's expired. The same goes if someone is sponsored on a partner visa previously. If they're then sponsoring for a partner visa, they do have limitations applicable. The last limitation mentioned, it's not here on the slides is there's a maximum of 2 sponsorships in a lifetime. A third sponsorship can be done, and we have done it successfully, obviously. But you need to show compelling and compassionate reasons. A most common one would be an Australian citizen child of the relationship. Okay, unclear relationship timelines. This can occur if there's previous information with the department on record from a visa applicant. For example, they applied for a previous visa and either didn't declare the relationship or had a different secondary applicant on that visa application. While there wouldn't be a sponsorship bar per se, the department they would have records of that previous application, and you would need to be very careful that the relationship timeline isn't inconsistent with a previous application made to the department, as the department could then try and nail you on false or misleading information, which can have very serious consequences. So it is important to be transparent with the department in all dealings. The next one is not yet being divorced. This isn't a limitation to applying, but again, going back to our question in the chat about minimum relationship evidence, not being divorced means you're unable to register a relationship in a state or territory and you're unable to marry. So you would need at least 12 months of a de facto relationship if you haven't divorced from a previous partner yet. A common country where this can occur, from our experience, is the Philippines, due to the absence of divorce in Philippines family law and only annulment being available. It makes it more challenging. So if someone's previously married in the Philippines, often you will need to be showing at least 12 months of a de facto relationship and applying through a partner visa stream rather than a prospective marriage visa stream. Not being divorced also rules out the prospective marriage visa entirely until the divorce has been finalized, because you can't marry if you're in an existing married relationship. Okay, relationships under 12 months. Again, going to our question, you can waive it. The most common is a registered relationship in the states and territories it's available, or compelling and compassionate reasons in those where a 12-month waiver isn't available. Again, the most common compelling and compassionate reason would be Australian citizen children of the relationship. Character or health concerns, these can significantly delay processing, especially if referred to the character consideration unit. The character consideration unit, from our experience, is very slow in assessing character, and if referred there, it can be a 2 or 3 year delay in the processing of an application. A waiver is possible on both health and character grounds. Character, a major red flag is a criminal record of over 12 months for either an applicant or sponsor, as that's considered a substantial criminal record under departmental policy. And the onus would be on you to effectively overturn that presumption that you're of bad character and demonstrate good character. Health concerns, the most common one is HIV that we experience. The main way to offset health concerns is, from our experience, showing that you have business or income that can well and truly cover the health expenses that may arise within Australia. So yeah, these are just 2 complications that could delay processing and increase the complexity of the visa application. Another one which may occur for HIV if it's a same-sex relationship is potentially the country of passport for the visa applicant doesn't have the same equality of rights as Australia has. That could be a ground with which you're waiving that health concern, because then the Australian partner would be in danger if they were made to live in that country. Again, as we mentioned earlier, visa status or bridging visa issues can create complications and require Schedule 3 applications. Visa status is a particular red flag if someone's been unlawful for a substantial period of time. So that's a number of years since their last visa expired. They've been in Australia. Most likely it'll be flagged by them holding a bridging visa E if a Vivo check is done, and that's how we'll become aware of it if it's not disclosed in our consultation. Um, yeah, this can create significant issues as you'll need to establish the grounds for the department allowing them to apply in Australia despite being not holding a visa in Australia and being considered unlawful by the government at the time they apply. Yeah. Okay, we'll get to Q&A. Yeah, final Q&A session now. ST partner visas offshore, if the evidence is strong, usually we experience 10 to 14 months as our experience. Standard processing times, as I mentioned earlier, it is 23 months for the 309 as the 90% processing time with the department. That means 90% of applications are decided within 23 months. I believe the median processing time is around 13 months as of the last update with the department. So those are the timeframes I'd be considering. But again, it could vary depending on the quality of your relationship, evidence, how strong the application is. Has your partner completed health examinations and provided police checks along with the application? Are there delays in those? What country they've applied from? What their visa history is? There's a lot of factors that come into processing times, so it would be hard to give an estimate for your particular partner. Okay, just wait for Daniel M's question while it's being typed. Yeah, so if you have concerns with an application, you can come to us. We do offer consultations where we could discuss the quality of the application and areas for improvements. Yes, the department will likely send what's called a Section 56 request, and evidence can be provided after lodging. So even if you've already lodged the application and you upload evidence after lodgement, the department will consider that. So for Daniel, they will consider that evidence you've uploaded after lodgement. However, they may have concerns as to whether, depending on the dates of the evidence you uploaded post lodgement, they could have concerns as to whether you were in an adequate relationship when you applied for the visa or only after you applied for the visa. So that's just something to keep in mind if you do want to have a consultation with us. But the evidence provided after lodgement will be considered. Okay. Yeah, as Daniel mentioned, if you don't have a joint account, you can provide annotated bank statements. Usually you'll be looking to provide statements from both yourself and your partner, and matching those transactions in the accounts either by highlighting or annotating the statements or identifying the transfer numbers of the accounts being transferred between in each statement. You may also want to provide a statement as to how you share financial responsibilities if you don't have a joint account. Yeah, we can work with people on the statements for sharing financial responsibilities in such circumstances where it's not clearly documented via something like a joint account. When you will get permanent residence, it's hard to say if you applied on the 24th of June 2024. If you applied on 24 June 2024, you either, if the 820 is still pending on 24th of June 2026, and the decision on the 820 and 801 is made together after 24th of June 2024, you'll receive an 820 and 801 double grant as the application would have been pending for over 2 years. So the department may actually be holding the application for a double grant of the 820 and 801 following 24th June 2026, as that will be the 2 years. Alternatively, you'll be eligible for an 801 submission on the 24th of June 2026, and on 24th of June 2026, you can apply for your permanent residency via the 801. So they're the two circumstances that could arise there. In terms of the actual permanent residency being granted, it's usually about a year processing, but varies greatly. For example, a couple of years ago, all our 801 applications in the system, we had 6 granted on the same day, as they just seemed to decide to grant 801s. But as the Department of Home Affairs, they vary in how they operate on a somewhat week-to-week basis. If you're not a PR or citizen, and you hold a visa for Australia, is it treated the same? No, you're not treated the same. You cannot sponsor for an 820, 801, 309, 100, or even a 300 if you're not a PR or citizen or eligible New Zealand citizen. If you're an ordinary visa holder, there is potential you may be able to do a subsequent entrant application. That would depend on the type of visa you hold, and the criteria would depend on the type of visa you hold. So you would likely be looking at more of a subsequent entrant application rather than a partner visa application. Just think about it from a common sense perspective from the government. If you're not a PR or citizen, you're not eligible to sponsor someone to become a PR or citizen. New Zealand, if you're a New Zealand citizen, though, you can sponsor someone for a 5-year visa, which is the 461 New Zealand Family Relation Visa, if you're not a New Zealand citizen who's not an eligible New Zealand citizen or Australian citizen yet. The 801 is a permanent residency visa, just to clarify. The 801 and the 100 are both permanent residency visas. Their travel facility on all Australian permanent residency visas, be it the 801, 100, or any other type of permanent visa, they're granted with a 5-year travel facility. So it's the 5-year travel facility that would likely have their expiration date. That means, for example, if someone's granted an 801 today, they can travel in and out of Australia as much as they like until the 15th of January 2031. Beyond that, it's permanent visa, so they can live in Australia indefinitely while being lawful in Australia as a permanent residence. However, they wouldn't be able to travel in and out of Australia. To do that, they could apply for what's called a resident return visa. That allows for permanent residents to travel in and out of Australia beyond the expiry of the travel facility on the 801. The reason for that 5 years is it's generally expected that people would become Australian citizens within that 5-year time frame. So the citizenship residency requirements, it's 4 years total residency with 1 year of those, with the most recent year out of that 4 years being as a permanent resident as a minimum. So usually someone would become a citizen well before the expiry of the travel facility on the 801. If they don't become a citizen, then they can apply for a return resident visa following the travel facility expiry if they want to travel. If they don't want to travel, they can live the rest of their lives in Australia following the 801 grant and the end of that travel facility as long as they're in Australia when it expires. So it is a permanent visa, and you can live in Australia permanently with it and go for citizenship, etc. Yeah, I hope that helps clarify, Daniel. So it's not a visa expiry, it's just the travel expiring. Thank you very much, everyone, and have a great afternoon.